Vodanovic. I'm joined today by Alice Richardson. We are both barristers at Trinity Chambers in Newcastle and Leeds, and we both specialise in housing law and property litigation. This is the last in our series of webinars dealing with local authority enforcement measures against private residential landlords and the appeal process in the First-Tier Tribunal Property Chamber. Alice and I will look today at the civil penalty notices appeal procedure and the process of dealing with these through to the appeal stage in the FTT. So civil penalty notices are financial penalties for offences committed by private landlords, such as those that we've covered in the previous webinars in relation to breaches of the improvement notices and other matters relating to the licensing of houses in multiple occupation. So CPNs, civil penalty notices, are a very useful enforcement tool for local authorities. And up until relatively recently, local authorities were only able to prosecute for these offences in their criminal courts. They still can, but in 2016, the Housing and Planning Act amended the Housing Act 2004 to bring in a power for local authorities to impose these civil penalty notices instead of prosecuting. The option of prosecuting is still there, as I say. It is not in addition to, but it's instead of prosecuting. So it's an important tool for local authorities as they get to keep the income from these civil penalty notices, so it can become a self-funding enforcement tool for them. Now, just because it's not a prosecution with a conviction at the end of it doesn't mean it can't be used for the more serious offences. It can be used for all types of offences. It leaves the option of prosecution, but for the vast majority of offences, I would have thought this would be the preferred and easier option than prosecuting. Still, the local authority has to make the decision what to do. So can you talk us through that process, Alice, in terms of what happens once they've made the decision?
Yes, so as Vilma has just said, the local authority, first of all, has to decide how to act, whether to prosecute for an offence or, where available, impose a civil penalty notice. And that's in the alternative to a prosecution. The key point is that there has to be an offence for either option, and that is an offence that can be proved beyond reasonable doubt, but it doesn't have to have already been proved in the criminal courts in order to be relied upon. It's suggested in the government guidance that we're going to refer to shortly and provide a link to, that the local authority may wish to consult the Code for Crown Prosecutors before taking this action. It's all about making sure that you've got enough evidence to satisfy the criminal standard of proof and public interest test. The imposition of a civil penalty notice instead of a prosecution can still lead to other consequences for a landlord in addition to the financial penalty. And the government guidance explains that in some more detail. But those are things such as rent repayment orders, in order to do the landlord to do the works. And if there's more than 2 civil penalty notices in the space of 12 months, the landlord can be put on the Rogue Landlords Register. But the focus that, or what we're focusing on today is appealing a CPN. There's only one penalty in respect of the same conduct or offence, and that includes a failure to act. The maximum fine for each offence is £30,000. We're going to come back to discuss this in a little more detail later on. The procedure is contained in Schedule 13, and that's a crucial document.
Looking then at what the relevant housing offences are for which one of these CPNs can be imposed, Section 249A2 tells us it's Section 30, which is a failure to comply with improvement notice, Section 72, licensing of HMOs, selective licensing issues of houses under Part 3, which is Section 95, failure to comply with overcrowding notices, and other breaches of management regulations in respect of HMOs. So we've covered these topics in more substance in the 2 previous webinars. So how is this process then started by the local authority? Well, it is started by the local authority serving a notice of intent, which kickstarts the whole thing. The local authority has 6 months from the date of the commission of the offence to serve one of these notices of intent, or if the conduct is continuing, so for example, a continuing failure to remedy defects in a property, then at any time during that period, a notice of intent can be served. But if the landlord has continued not to comply for some time, but then decides ultimately to comply and remedy defects, the day on which they are remedied finally then becomes day one of that 6-month period for counting purposes. So once that notice of intent is served, the appellant has, or the landlord at the time, has 28 days to put in their written representations. That notice of intent is crucial for a number of reasons. As an appellant, it has to tell you what you've done wrong so that you can ultimately make those written representations. And we can see from paragraph 3 of Schedule 13A, the notice of intent has to tell you the amount of the proposed penalty, the reasons for proposing to impose it, and the fact that you've got the right to make written representations. So these are technical requirements which have to be complied with. It's very important to have the opportunity to make those written representations, and they need to address the factors that will be looked at by the local authority, and we'll come to those in a moment in a little bit more detail. Alice and I have been involved in dealing with appellants at this stage. What you often see with these appeals is that appellants bury their heads in the sand, ignore it, they don't put in written representations, or if they do put in written representations, what they talk about is the unfairness of the system rather than addressing the points. So getting some legal advice or some assistance at this stage can in fact be quite beneficial to appellants, because it might reduce the amount of the final penalty that's imposed by the local authority, or depending on what you put in, it might make the local authority think twice as to whether it can in fact prove the offence that they say you've committed as an appellant. So this stage of the process shouldn't be underestimated, it's certainly my experience. We've looked at the notice of intent and the technical requirements imposed by Schedule 13A, but what happens if those requirements haven't been complied with? What's the effect of that? And we're going to discuss a case of Waltham Forest and Eunice. This was a case decided last year by the upper tribunal, and it concerned a property which was under selective licensing with some conditions which were imposed as to what the occupancy agreements of those occupants should have within them. And it's all to do with antisocial behaviour, really. So allegations came in to the local authority that there was antisocial behaviour happening, that those conditions had effectively been breached for various reasons. So the local authority issued a notice of intent to the landlord, but it was very vague and general in the letter, and it simply said that an offence was committed, but didn't explain how. There were numerous statements attached to the notice of intent, but the letter itself was very brief on the point. So the technical argument was raised that the contents of the notice of intent weren't as per Schedule 13A, and that the whole process was therefore a nullity. So that was the argument. So it went up to the upper tribunal, and tell us what the upper tribunal decided, Alice.
Well, the upshot of what was decided is what's set out on the slide here. The tribunal held that the characteristics of the scheme suggested that the reasons given in a notice should be clear enough to enable the recipient to respond, but they also suggested that if those reasons are unclear, unambiguous, Parliament couldn't have intended that the notice of intent would invariably be treated as a nullity. And they talked about the seriousness of offences for which civil penalties can be imposed, the relatively short time frame available for a local authority to serve one, and the availability of a right of appeal. They thought that they were all features of the scheme which militated against an overly technical approach to procedural compliance. Upshot really is failure to comply won't automatically invalidate the notice. It may do so, but even then there's a discretion as to whether it's to be treated as wholly invalid so that it can't be relied upon. We're going to move now to talking about the imposition of a final notice by a local authority. This is after the local authority has decided on the level of fine, they've given reasons for doing so, they've taken into account written representations, and then they've imposed the final notice. And that final notice will tell you how to pay it. If you don't pay it and you don't appeal it, it will become a debt enforceable in the county court. If you think it's not justified, you can appeal, and that's an appeal as of right. A properly lodged appeal will stop the requirement to pay until after the determination of the appeal. The Housing Act 2004 doesn't actually deal with the timescale for an appeal, but the tribunal rules provide for 28 days. You can make an application to appeal out of that time if you've missed the deadline, and the tribunal does have a discretion to allow an appeal out of time, but you would have to have a good reason for it. And what may or may not be a good reason is fact specific depending on each individual case. I know I've certainly been involved in a case where the appeal was filed late because the notice itself did not make clear that it was a 28-day time frame, and it referred to the wrong regulations in which to find that time frame. So that may well be a good reason. Appeal of a final notice can be in respect of a number of matters. Set out some of those on the screen. It's important to note that this is an appeal by way of a rehearing, so all matters will be taken into account, even those that the local authority didn't know about. And we're going to take you through each of those in turn. They're set out on the screen there. Commission of offence, the standard of proof hasn't been met. You've got a reasonable excuse defence. There's been some sort of failure to comply with process, or you might appeal the level of penalty imposed. That seems to be a fairly common one in my experience.
So the grounds of appeal can challenge the fact that there's been a commission of the offence itself. So you can say that it's not proved that you've committed the offence, and it's not proved beyond reasonable doubt, and that's the key point. So it's all about the evidence that the local authority has against you. There's no conviction from any court. The local authority itself has looked at the evidence it's got and decided it's got enough to prove something beyond reasonable doubt. So you can challenge that as an appellant by saying that there isn't good enough evidence, there isn't enough evidence. And it will be for the local authority at the tribunal hearing, at the appeal, to prove to the tribunal that the offence has been committed. So you can challenge this, and there'll be a rehearing, and it may well be that you've got other evidence to put in as an appellant. It may well be the local authority is relying heavily on hearsay evidence. So your oral direct evidence is going to weigh more, hopefully, than that hearsay evidence. So the tribunal will decide the matter by rehearing it. It doesn't deal with the process the same way as the criminal courts would do. The tribunal rules apply, they're more flexible, there is a more fluid process. And if you're the appellant, you're unlikely even to be giving evidence on oath, which is quite different to what you would have in the criminal courts. You may be required, or some witnesses may be required to give evidence on oath if there are particularly controversial issues. But it's, as I say, for the local authority to prove and to bring good evidence to the tribunal. So that might be one of the grounds of the appeal. The other ground that is often overlooked by appellants, I find, is that of reasonable excuse. And it may well be that you can say, I've not committed the offence as the appellant because you have a reasonable excuse in not complying with whatever measure was imposed on you. Now, even if you haven't specifically raised this as an appellant, the tribunal has to look at it. The tribunal has to consider it. There was a recent case this year in the upper tribunal where the First-Tier Tribunal was reminded that it should consider whether any explanation given by anyone amounts to a reasonable excuse, whether or not the appellant has raised it himself or herself. So if you are the appellant raising this or the tribunal's considering it, the burden of proof of that reasonable excuse defence is on the appellant, but the standard of proof is a civil standard of proof, so it's a balance of probabilities, so easier to prove than the commission of the actual offence that's the burden that's imposed on the local authority, which is the criminal one. So if you're the appellant, useful for you to know that the tribunal will consider this in any event, but it's something that you as the appellant should be considering from the outset, because if you've considered it early on, you'll have a better opportunity to prepare yourself and to put evidence in response to it. And if you're the local authority, the fact is that you should be prepared for dealing with it, even if the appellant hasn't raised it, because the tribunal will look at it. So you, as the local authority, may want to consider what other evidence there might be to counter anything on that particular point. And there are two other matters that we said were usual grounds. Alice, do you want to take us through those?
Yeah, so the first one would be some kind of failure to comply with technical or procedural requirements. That's such as the Waltham Forest case we talked about earlier, where they tried to argue that the whole process was a nullity and therefore the decision to impose the civil penalty notice should be quashed. The First-Tier Tribunal would want to know the details of the process, and there may be points that can be raised about the process taken by the local authority. Useful pointers from the Waltham Forest case as to what should go in the notice of intent also helps with the final notice. They say that the reasons should be easily understandable and contained in one document without reference to too many other statements and documents. Headlines are fine as long as it's backed up with a concise statement of fact. In the Waltham Forest case, the upper tribunal said a concise statement of the fact said to amount to a breach of the licence condition or other offence would be preferable to the practice of providing particulars by means of a number of other repetitive witness statements. Lastly, as I said earlier, a common ground of appeal is of the level of the penalty, and there are a number of factors to be taken into consideration here. And there's government guidance on this, but local authorities should also have their own policy, which take into account that government guidance and then develop it. So this is the link to the government guidance, and you should be able to click through on that on the PowerPoint. An appellant should be provided with this at some point. Local authority will cite from it. And the local authority's own policy should be available from their website in any event.
The government guidance is issued for all local authorities to take into account, but also for them to produce their own policies. And what they do is they recreate those factors that are listed in the government guidance and sometimes expand on them or add some of their own. So, for example, the level of assets and income isn't in the government guidance, but is something that local authorities do look at and tribunals look at. And here we're not talking about just rental income, but we're talking about all assets and all income. And this is clearly going to be relevant in informing the local authority as to how much a landlord has to pay the fine and whether it has the money to pay the fine. And then the other factors that are listed in the government guidance are the severity of the offence, obviously, that is a crucial one, the culpability and track record of the offender. So the local authority will often get evidence of other offences or dealings with other properties where the same landlord is involved. And if that particular landlord has a particular disregard for the safety of others, and that can be evidenced in respect of dealings with other properties, or even the one in question, if there's a particular delay in dealing with issues or simply a disinclination to comply promptly with the enforcement action, all those factors are going to be relevant as when it comes to this particular point, the culpability of the landlord. Harm caused to the tenant, if the tenants are particularly vulnerable, elderly, That's going to be a factor. The punishment of the offender, of course, is another factor that they will take into account. One of the points, though, to consider if you are the appellant, is to make sure that there isn't overlap of punishment between the two parties, both of whom are fined, which you often find in relation to provisions to do with houses in multiple occupation, because you might have the licence holder and the person managing the property, both of whom have been fined. So you don't want there to be too much overlap there. And then the deterrent effect on the offender and others, and of course looking to remove any financial benefit that the offender might have obtained as a result of committing the offence.
As an appellant who wants to challenge the amount of the financial penalty, those are key areas that you need to focus on. Have the factors that Vilma's outlined been properly considered? And is there something else that you want the tribunal to consider? And that is what your witness statement would need to focus on, and all your evidence needs to address. And remember that the FTT can take into account matters which were not before the local authority. So you can include new matters in your witness statement or in additional grounds. You can also consider whether there's something that should have been given more or less weight in your favour. Those are the factors that the guidance focuses on, and the status of that guidance is quite important, as we'll see.
Yes, so as Alice said, the guidance is extremely important, and those local authority policies that arise from that government guidance are the starting point, not just for the local authority, but in fact, as we've seen from two very recent upper tribunal cases this year, that really the tribunal itself, considering any appeal, should start from that policy, give it proper consideration, but also give proper consideration to any arguments that it should depart from it. So it's the appellant who has the burden of persuading the tribunal to depart from that policy. And in considering reasons for departing from it, the tribunal has to look at the objectives of the policy and to ask itself whether they would be met if the policy was not followed. The best way, if you're the appellant, that you're going to persuade the tribunal, I suppose, to depart from it in the absence of complete failure to follow it by the local authority, of course, is that if there were mitigating circumstances for you as the appellant that the original decision maker, that is the local authority, wasn't aware of, or they didn't take sufficient account of it, and you've brought more information on that particular point. So in those circumstances, it can be easily justified as to why they might depart from all those factors or the interpretation of those factors. So those are the two cases that effectively say the same thing about the importance and the status of those of the guidance and the policies, and that they should be followed.
Lastly, we just wanted to talk about the key pointers for you to take away from today's webinar. Firstly, for appellants, really the importance of getting those written representations in, get them in and get them focused on factors that we've talked about, or indeed point out difficulties with the evidence in proving that the offence was committed. For local authorities, your clarity of reasons given in the notice of intent and the final notice is incredibly important so that you don't open yourself up to a technical challenge. You've got to look at, has the offence been made out? Is there a reasonable excuse? For the appellant, if there is, how are you going to deal with it? For the local authority, be ready to deal with that argument if it is run.
Yes, I agree with all those, Alice, and I would just add that these appeals can be tricky for those who don't have a lot of experience in dealing with them. And there are various stages of this process at which, if you're the appellant, some legal advice might actually save you money in the long run. Or it might take away some of the headache in dealing with the process and the final appeal. So it might be worth seeking some guidance or advice if you are dealing with it for the first time. So I hope you found this webinar useful and the series of webinars. If you have any questions, please do get in touch, and thanks very much for watching.